on State versus Blandino, KC 341-767. Who's here for the state?
Mike Dickerson on behalf of the state, Your Honor.
Okay, and Mr. Bateman?
Yes, good afternoon, Your Honor. Ben Bateman, bar number 9338.
Okay, and Mr. Blandino, I can see him. It appears as though he is appearing via Blue Jeans, so thank you very much. I mean, I'm assuming the state's had an opportunity to review this motion?
We have, Your Honor.
Okay. Mr. Bateman, I just have a couple of questions. I mean, because I know you're indicating you have to withdraw because continuing to represent him would require you to violate the rules of professional responsibility, but I'm not sure I understand that.
Okay.
Because it's the attorney's obligation to set the trial strategy. Correct?
That's correct, Judge.
Okay. And it's up to Mr. Blandino if he wants to cooperate or not. And if he chooses not to, I guess he does that at his own peril. But it's my opinion that this is just more of the same obstructing and impeding. You know, let's see how many lawyers I can go through. Is there?
Well, Your Honor. Well, yes, he is not right. He is not cooperating. He's not, the stages of grief. He's not to acceptance stage yet. That his self-representation has been revoked. He, in his letter that's attached as exhibits, the letter to Judge Bell, the writ of habeas corpus that he proposed, in it he and I did speak to bar counsel. In it, he intends to, despite my efforts on trial strategy, Judge, to use his right to testify as a defendant, and regardless of the question that I ask, what's indicated is to bring up Your Honor's judicial disciplinary record, that sort of thing, partly to, I guess, state that he is.
You can let me worry about the evidentiary issues, because at the time of trial, the court will conduct and determine which issues are relevant and which are not. I mean, I know your concern would be questioning him if he did take the stand and testify. If at that time you represented to the court that he wanted to give testimony that was inconsistent with what you thought was appropriate, I can allow him to testify via narrative, and you would not be required to ask him any questions.
Okay. Well, despite that, Judge, then
that issue, I don't want to put you in that type of a position, but I mean, Mr. Blandino is not going to testify about a bunch of irrelevant and inappropriate things. So, I mean, you can, the court.
Well, right. I mean, that's specifically right. As rule was it 4.4 that I referenced to, used to delay, embarrass, or burden a third person or disrupt the tribunal, which is rule 3.5. But also, Judge, his communication is not happening. My meetings with him are unproductive because I think the skill set, I think it's probably because I've been on this case for a while. The skill sets that I had, I guess, as standby counsel are very different than being lead counsel. And I think perhaps there was obviously I filed motions, I filed things that I would never file as an attorney for Mr. Blandino because he was his own attorney. I think perhaps there was some belief on his part that I sort of was in agreement with his trial strategy, his overall strategy, which I was not. I have my own. And so all these meetings, since his revocation, I mean, basically, are you going to do this? Are you going to do that? And basically, no, these are the things that we need to work on, and they don't happen. And so it's obviously hindered my ability to represent him and to be prepared. Additionally, he said things in these letters that he made public to Judge Bell and in his writ, attributing statements to me that I've never said. that you were, I don't know, one was that you were irredeemably biased, that I'm undecided if I'm going to call Judge Bell as a witness. There's no doubt I have never wavered that I'm not going to call Judge Bell as a witness in his trial, or that I won't file any pretrial writs. You know, the writs that he wouldn't file when he was his own counsel, you know, I'm not obligated to file those now that I'm counsel, because I believe they're meritless. And so, Judge, this is where we're at, that I'm not really getting you know, any help from him. You know, obviously I know he's been you know, he believes that he needs to be his own attorney, and that his right to self-representation was taken from him unfairly, and therefore he's not cooperating with me. I don't know if I know Your Honor is loath to continue this or even stay this till his remedies are exhausted. I don't know but I think I do. You know, we're at the point where I feel it's necessary to withdraw, because I'm not getting anywhere with him.
Mr. Bateman, let me just interrupt right now. First of all, I have confidence in you. You're an officer of the court, that you're going to comply with all the rules of professional responsibility. I'm not worried about that. What I am worried about is Mr. Blandino continuing to obstruct and impede the state from going forward. So if he continues to choose to not cooperate, he does so at his own peril. But obviously, you're the attorney. You get to determine trial strategy. And so, again, if he fails to cooperate, he fails to cooperate at his own peril. I mean, I don't know what else to say. There will be nothing different if I appoint another attorney. It would be the same thing over and over and over again. So his self-representation, I have revoked that. He is now represented by counsel. You know, I know he's not happy about that. I know he objected to that. That objection is noted in the record. It's preserved for any appellate review. But I have to tell you, I'm not inclined to grant the motion to withdraw based on what's in front of me. Anything else?
All right. No, Your Honor.
I mean, again, I just want to thank you for your willingness to do this case. I mean, I understand the position you're in. It's up to Mr. Blandino to determine whether he wants to cooperate or not. And again, if he chooses not to, he does so at his own peril. So, does the state want to be heard at all?
All right.
Mr. Dickerson?
The only thing that I would say is my assessment of all this, Your Honor, is that this is something that doesn't appear to be unique to Mr. Bateman or only him.
Exactly.
I have sympathy for him in this situation, but I think that this is going to be any defense attorney in his situation.
Right. I mean, and that's the opinion of the court, that it wouldn't matter who was appointed. We would have the exact same issues. I mean, we're close to trial. We're less than 30 days out for trial. So at this time, I'm going to deny the motion to withdraw.
All right.
Let's try to recall page 13.
Thank you, and thank you for your patience.
Thank
Do we
you, Your Honor.
have